Well, I'm Shane Smith, and I want to thank you guys for coming to this. As many of you know, I'm the owner of law offices of Shane Smith. Ron, who's going to be talking for the most part, is my managing attorney, and we have 2 litigation associates. And one of the things that has come up in our practice is we've started litigating more and more of these cases where it's soft tissue type cases or even some of the lower impact or missed cases. Sometimes a deposition is necessary from the doctors we work with, and as we talked to some of them, we found out that many times the doctor hasn't been deposed in 3 or 4 years or more, so they have questions. And what we wanted to do was have a little talk to try to answer some of those questions in a learning atmosphere, as opposed to asking questions the day before you get a deposition, before the deposition or the morning of or something like that, just so you're better prepared and you know what to expect, so some of that anxiety is gone, or as a refresher in case you haven't been deposed in 10 years or more. Although I don't think we have, you're the only one who might be old enough. Ron here has been in my office for about 6 months. I've known him before that. He's been doing straight personal injury for probably 18 years or more, and has done thousands of cases to completion in and out of the courtroom. So he's totally competent to answer any questions you might have. If you have any questions while this is going on, feel free to ask the questions. We'd much rather that than try to hold off to the end. We want it to be more of a conversation or lunch and learn type thing. The normal atmosphere of what we try to do when we litigate these type of cases is we try to do a medical narrative, which Ron is going to talk about, which doesn't require you to come in or be deposed or anything like that. But the next step then is, of course, the deposition, or a videotape deposition is at trial. But with that, I'm just going to turn it over to Ron, and he'll take it from there.
Thank you. Again, my name's Ron Smith, talking about depositions. And let me just find a place that I may be comfortable at. Really, I'm going to try to go from the very beginning to the end of the deposition and kind of touch on some of the crucial areas, but even be detailed in what may be covered. But so you've been called to have your deposition taken. What should you do? Well, the first thing is, I think that's very important for the doctor, is to set the deposition in a place that is convenient for you. Don't think that you've got to come to the attorney's office. Don't think that it's got to go to the courtroom or anything like that. Set it at your office so that you are not inconvenient more than you have to be, and that you're comfortable, because you're going to be the star of the show. So I think it's always important to have it at your office. And there are other issues that may come up too, is the file may be needed, and you can easily grab that file. So the next step, I would say, is the file. You don't have to do it days before. I think it's important, though, that the file be reviewed, and it could be reviewed just maybe 5 or 10 minutes before you go in and meet the attorneys. So that you can look at it and go, oh yeah, I remember that client, or that patient, excuse me. And you can just have that refreshing familiarity with the person that you're about to talk about. So take 5 or 10 minutes, review the file. If you've treated them for a lengthy amount of time, maybe you'll need a little more time, but you know what time. But I think that's very important to review the file. The other part, and this is kind of where setting your rate. What do you charge? I think if you ask any lawyer, they're going to say, set that rate as low as you can. We're trying to help you out. But set it, but don't set it to where you're pricing the attorney out of being able to take your deposition. Set your rate at what you think your hourly rate is worth, and I would maybe even want to put that in writing, so that if you're called to be deposed, you can just fax that over. The attorney knows right away how much they're going to be charged, and there's no question about it.
Okay, Ron? What time do you normally have to set the deposition for?
As far as actual time,
Yeah, does it have to be during the duty day, or can it be after hours?
and
What flexibility is there?
I think the doctor should control that, because I've fortunately have never had to do this, but we've had depositions set at 7:30 in the morning, but we've had them as late as 8 or 9 o'clock at night at lunch. But set it at a time that is good for your business. If you're closed on Wednesday mornings, set them Wednesday mornings. I do know of one doctor, if you want his deposition, it's going to be Wednesday night at 6 o'clock. That's it. He doesn't give it any other time. So I think it's something that you should take control of, is setting that. Now, there are occasions where the attorney may be in a panic and may need your testimony quickly. And again, you are in control of the situation. You said it, though. But he may be in a panic. You may want to work with him a little bit. Get him on the phone and talk it out. Yeah.
What's the going average rate per hour for deposition for contract?
It's going up and up. I think $500 an hour is what you're going to see.
Thank you.
And not for us.
Not for us. But I've seen it 3 times as much as that, and it gets to where if you have a case that you have a little bit of treatment and there's not a lot of bills on it, the case can't afford it, and then you're getting into issues where I need your testimony to present the case, but yet you're going to run my cost up so much that I can't get your bills taken care of.
Yeah, and that's the main thing to really think about when you're setting the deposition, especially if it's the plaintiff's attorney who's trying to depose you. If your deposition fee is high and it's a smaller bill type case, it may be very difficult. Now, if that case later went on and they got referred out for an MRI, and then you referred them over to pain management, and they got a surgical consult and had surgery, clearly that's a much different case than one where they saw you for 8 to 12 weeks and they got better, or something where the property damage in the car was $1,200 or something like that. So you shouldn't really change your rate, but just be aware of the types of cases you are getting deposed on when you set that.
And I would expect a phone call from the attorney to, hey, that's an issue, can you work with me? And remember, he's asking you that so that he can get your bill taken care of, because he needs your testimony. The other thing, this may seem kind of minuscule, but make sure it's on your calendar. Have gone to a deposition and the doctor's not ready, and why are you here? And when you're trying to get a videographer there and a court reporter there and defense counsel there, plaintiff's attorney has kind of got a lot of money at stake, so make sure it's on your calendar. But anyway, all right, it's time for the deposition now. Everybody's there. Have the entire file with you. I had occasions where the records have been produced to us, the records have been produced to defense counsel, and the defense counsel asks that you present the file. During the deposition, you open it up, and there's notes that the client may have written in as far as what happened, as to why they're there, and that was never produced, but it's just kind of notes between the patient and the doctor. Make sure you produce everything and make sure you have everything at the deposition, because I don't think the plaintiff's attorneys will make a big issue out of it, but defense counsel will try to make an issue out of it and to try to discredit the testimony some way. Oh, you didn't produce this. Why wouldn't you produce this? So make sure you have the entire file. This, to me, this is this next section or next area is the most important part, and that's meeting with the attorney right before the deposition. And basically to just go over what kind of treatment did you give? Is there anything about this client that you remember that I need to know right away that's not in the records. But the ultimate question should be discussed then, and the ultimate question is, did that accident, did that fall, did that work injury cause the injury and the treatment that you gave? I think that question needs to be discussed between you and the plaintiff's attorney before the deposition. And I would even go so far as, if you know, the attorneys are there, the court reporter's there, you come in, hey, how's everybody doing? Look at the plaintiff's attorney, do you want to talk to me a couple minutes beforehand? I would even initiate it if he doesn't even ask. And y'all step out in the hall, have a conversation, hey, I think this is related. However, this happened at my last deposition. I asked that question, doctor, I'm going to be asking you, is this related? No, I don't think this is related. I think it just kind of aggravated the situation. And so immediately, okay, I need to adjust my questions, but at least I had a couple minutes to adjust my questions and be prepared for it. And if that is your opinion that this was an aggravation of a situation rather than a cause, let the attorney know. Because catching them blind on video or just during a transcribed deposition, it doesn't come out for the plaintiff's attorney very well. So I think it's very important to have that 5 or 10 minute conversation. Yes?
You mentioned about some things about the patient that the attorney should know, such as?
This patient really was a pain to deal with when they came in. They weren't very good as far as listening to me. They told me some things that I didn't put in the record, such as they got a drug problem. They got family problems that I think may influence your case. Something that says that they're not going to be a very good witness on the stand.
And right along those same lines, even if you put it in your record, don't assume that that lawyer saw it or read it. I mean, I hate to say that, but they may have missed it. I mean, if you put in there that, you know, she had drug problems, or maybe they were non-compliant, or maybe there's this gap of 2 weeks in the middle of the thing that, you know, in your questions with the attorney beforehand, he doesn't bring up. You know, you might say, hey, there was a gap with this patient of 2 weeks. How do you know, are you going to ask me questions about that? Or, you know, when they had that gap, I put in there that, you know, she tried to go back to work, and when that didn't work, she came back to see me. Or bring up those issues that you saw in the file to the attorney, one, so he's prepared, but two, so he can talk to you, and you might be better prepared about it. And the assumption, if you're preparing and you read it all, is you probably are going to know that file better than the lawyer. Or at least you know, it's good to know. So if there are those issues, point them out to the attorney in the preparation, so at least you guys are on the same page and you can talk about it, rather than it be a surprise, or you're assuming if he was going to ask you questions about it, he brings it up to you. And when it gets to aggravation of a condition, that's where those pre-existing conditions and the history is going to come up. And I think Ron will talk about that some later as well.
The next part, little quick step or quick hint is make sure you sit near the court reporter, because what you say is the most important thing at that moment. And make sure the court reporter hears you so that it gets taken down. And then if this is a video deposition, and that's the hard part about a video deposition, it's our natural instinct when somebody is talking to us or conversing with us, which is the attorney to the side, is to sit here, or you got your camera here, to sit over here and have a conversation like this. Well, remember, you're the star of the show, and the show's going to be played back to the jury, and look at the camera, because you're actually talking to the jury. Plaintiff is just throwing questions at you, and look at the camera, so that when the jury sees it, they see somebody actually talking to them. They don't see somebody turned to the side getting the profile view. Okay, so now the deposition finally starts. you get sworn in, part of the act, if you're being videoed, actually do the raising of the hand. It looks better when it's played back to the jury. They see that it's real, because you are actually, I mean, you're the actor. You're the most important person at that time. So actually try to portray what is really going on and really believe what's going on. And you're not just doing it for the benefit of the client. You're doing it for the benefit of your own bill and services. So I think that helps right there. So the questions start. It's going to be general. What's your name? Where's your practice? Give the name of your practice. That's a little free advertising to the juror. Tell them where you're practicing. And then what is your educational background? You need to start from college through medical school, through interns, residencies, whatever you've done, even writing, publishing any articles. I think that's important for that to be said, because then it gives you a lot of credibility as to what you do and what you're about to say. And it also, it's to qualify you as the expert of what you're doing. Some attorneys may baby step you through it. It's kind of nice, though, when, doctor, can you tell me about your educational and background history, that you just spill it out, rather than having to baby step each question. It just kind of presents a little better. Then the big question, the attorney should know to ask this, but if you're being deposed, are you licensed in Georgia? That needs to be asked and stated. So if you're just kind of spilling it out, don't forget at the end, yes, I am licensed to practice in the state of Georgia. I'll talk a little bit more about exhibits, but one thing that will come up, that especially in a video deposition, is x-rays and MRIs. It may be asked, have you been trained to take x-rays or read x-rays? Have you been trained to read MRIs? I think that's something that needs to be stated. It may not be covered at the beginning of when you're giving your educational background or your work history, but before an exhibit is presented into evidence, that should be taken care of and be looked at as to what you know. Can you actually read it and talk about it and comment on it?
Yeah, and one thing when you're talking about your history and your education, most chiropractors, your school has enormous amounts of hours and hours on physiology and anatomy and all of those kind of things. I think it's okay to talk about that. So even just saying, well, I went to chiropractic school at Life or wherever, it's okay to say one of those things, and part of that, some of our coursework has 60 hours or however many hours of human anatomy and physiology, so you can talk about some of that. Now, you don't want to talk about every single course or go on a long talk about all your schooling, but it is okay to highlight one or two big areas. What I would not do is I would not compare you directly to a medical doctor. I wouldn't say, and I talked to one chiropractor and he said, we have this many hours and your regular medical doctor only has this many hours of human anatomy. You don't need to do that, but I think it's better to highlight all the things you do have and all those hours of training. It just bolsters it, and it makes you sound more like an expert than if you just say, I went to chiropractic school at Life or something like that, or I got my degree at Life University or whichever chiropractic university. It's a little more details, and it just bolsters it a little bit better. Okay?
And one of the reasons is that if we're trying to get an MRI into evidence, and we're using your testimony to lay the foundation for that MRI, if you give your background and your history of reading MRIs, it helps us if they try to block or attempt to exclude the MRI, that you were qualified to read it and order it. So that's where we need that to help us get the judge to rule in our favor. Yes?
The dilemma I have is that I'll have patients have x-rays. When I interpret them, they're far different than when the radiologists interpret them. How do you handle that?
That's a fantastic question, and unfortunately, the difference is going to be ammunition for the defense. I think what you really have to do is the plaintiff's attorney really has to state, all right, how long have you been reading x-rays? How long have, what kind of training did you have? Is this something that you've done on a normal basis to try to just bolster your testimony? And unfortunately, it's going to be a difference in testimony to, it's over there, Shane. Yeah. It's going to be a difference in testimony that's going to give the defense some ammunition. There's not a great way of dealing with it.
One deposition I did, the defense attorney's father was a radiologist. He said, well, you're not a radiologist. I didn't purport to be, but he's trying to compare. You don't have the knowledge a radiologist does. Okay.
And when questions like that come up, what I normally recommend is just confront it head on. And what I mean by that is if you act defensive, sometimes it seems like it lends weight to what they're saying. Whereas if you just say, no, I'm not a you just say it right out there. No, I'm not a radiologist. When I look at an x-ray, these are the things I'm looking for, which may be different than what the radiologist was looking for. And you can sort of qualify it that way. If you talk about what you were looking for, that, I was looking for this, I was looking for this, I was looking for this, and this is what I found. And that's when having exhibits and diagrams is so important, because if you can put the x-ray up and you can say, I was looking for these things, and this is what I found, it's here, and it's here, and you're talking about it, it lends a lot of weight to it, and a juror can look at it and say, what? I see that, or at least you explain it very good. Then it sort of gets past some of that bias or some of that you're not a radiologist, because they're not going to bring the radiologist. They're not going to do a deposition of the radiologist probably, or if they deposed the radiologist before, he may not have discussed the things he was looking for that you did, and if they depose him afterwards, and you did a good job of educating what you were looking for specifically, it may be something that he can't contradict. So that's what I would recommend in that situation. Yes?
Actually, I can kind of relate to what he's saying. So I took a seminar a couple of years ago, and the actual lead seminar speaker actually stated, you just put down that you reviewed it and received it, and then you also state a chiropractic analysis of the radiology report was done or whatever. That way, and you will kind of have some leverage that you were looking for something totally different than the other provider.
Exactly.
All right, thanks.
So that's kind of your background, covering your background. Then the actual real questions come into play. First question should be, discuss the history of the patient. Why are they there? What brought them to your office? What did they complain about? Then get into your physical exam. On that issue, I know that there are several different types of physical tests that you perform. The struggle there is you want to keep the jury's attention, or the juror's attention. So I don't think it's important to go over every test that you go or did. I think it's important to touch on the ones where you found a positive result. And that way, now, of course, the defense is going to come back and say, hey, wasn't this a negative, wasn't this a negative, wasn't this a negative. They had no positive findings on any of these. But in order to keep the jury's attention, state what I found what the problem was, this is what it was, and this is what this test is, and this is what we're looking for. Short, concise, to the point, to keep the jury's attention. Yeah, I like that. Some attorneys may not, but keep it brief though. so you don't lose the juror's attention, because that's always the plaintiff's attorney's biggest fear. You want to keep it entertaining for them, because the jury doesn't want to be there to begin with, so try to keep it short and simple. I think I was kind of taught old school, go through everything, and you'd have a 2.5-hour deposition, and now I think it's kind of morphed in, you see some other people, and I kind of tend to agree with this, have a short, sweet, concise deposition, and you get better results from the jury with that. Then, of course, give your assessment. What was your assessment? Whatever terminology or whatever the injury is, whatever the medical term is, that word is going to be over every one of the jurors' heads. So if it's cervical radiculopathy, very important you explain what that is. And there's a lot of times the attorneys don't even know what that means. So state it. This is what that means. This is the part of the body that is injured. And then you get into your plan. This is my assessment. This is my plan to get them to make them better. Kind of state what each one of those are and explain what they are. Just give a brief description. And that's usually, we're kind of covering that first day of treatment or the second day of treatment. I don't think that needs to be done on every visit they came to. Hopefully you've kind of established what the problem is, you've established a plan, and now you're describing what the plan is. Okay, we addressed this plan for 4 weeks, and then we did a reassessment, or we did this plan for 8 weeks. So again, that you keep the jury's attention. This is, I think, a question also that comes up is, what's the difference between a medical doctor and a chiropractic doctor? I think it's very important that you explain our approach is more of a hands-on, non-invasive approach to try to help the person become better. I think it's very important that be explained, and so the jury understands that. I don't think it's something that should be explained that we can fix everything, because not every doctor can fix everything. And give your theories as to, this is why I'm a chiropractor, this is the way I do it, and this is how we try to achieve the goal of getting a person better. Yes, that is different. An MD may prescribe medication. They may try to do injections. That's more evasive. Sometimes that's not what the patient wants. So I think it's very important that you distinguish that difference, because it usually will come up, and be prepared to make that distinction at some point in the testimony.
Yeah, and one of the things is some chiropractors are very hands-on. Others use a lot of the devices that are the pressure devices, or right, exactly. They use those, and if you do that kind of therapy, I think it's important to talk about the fact that you do that type, okay? And that's just one thing, because y'all know everything you do, and you know all the ways chiropractic has progressed and grown through all the research and how it's changed from the way it was, years and years ago. If there are these new techniques that you're doing, I think it's good to talk about them if you did it to this particular patient, and explain it, though, because if you say what you do and you don't explain it very well, everybody just missed it and doesn't get it.
The last part that will come up, you've set out a plan, and the question should be, was your plan reasonable and customary? Be very confident in that answer. That's something that we really need. Yes, it's very customary and reasonable to treat this person for 8 weeks, then reassess. Or however long, whatever you think, but be very confident and use those terms. because that's something that we need to present to the jury. All right, next little section is future treatment required? Let's say when you're treating this client, we're already in litigation, and they're still treating with you. And we're having to push the case forward and get it ready for trial, and we come in, and you think future treatment is necessary. Be confident in that. Be confident in explaining how, what type of treatment plan and how long you think it may go. That is something, and then the cost. I think it's very important that you explain your cost, because that's something that we will need in presenting the evidence. I mean, I have no idea what future treatment somebody may need, but hey, I think this client needs to come in every 3 weeks or 4 times a month, and it'll be $100 a visit. Whatever your rate that you charge, lay it out for them, because that's something that we'd be presenting as evidence in the case.
And when talking about future treatment, be sure to distinguish future treatment for this injury versus future treatment for overall wellness. And because one of the follow-up questions the defense attorney might ask is, well, doctor, how many of your patients do you recommend all need future treatment? Well, it's easy to say, well, for an overall wellness perspective, we recommend most people receive this. But this is future treatment specifically for this injury to this part of the body that they're going to need this treatment on, whether or not they do any wellness treatment. That way you can qualify that this patient is different than maybe all the other patients that transition into wellness. Does that make sense? All right, thanks.
Okay. Next section, the ultimate question. This is the most important question the plaintiff's counsel is going to ask you. And we talked about it earlier because you're going to talk about it in your meeting with the counsel beforehand. But the ultimate question, is this injury related to this accident? Usually that question should be kind of a lengthy question that the plaintiff's attorney asks you. Assume the person's in their normal state of health, that on such and such date they were in an accident. Assume that you saw them on so-and-so date and they were complaining of X, Y, and Z, and you conducted a physical examination and your diagnosis was X. Assuming all those factors to be true, do you have an opinion as to what caused the injury? Yes, this caused the injury. If you don't feel that it caused the injury, if it aggravated the injury, that's why we need to have that meeting beforehand, because when that ultimate question is asked, you have just affected the value of the case. If you say, no, I think it's just an aggravation of a pre-existing condition, the attorney needs to be aware of that beforehand so that he can kind of adjust his questions. So the ultimate question, was it related? Yes. If it wasn't, make sure you give that heads up to that attorney. What defense counsel is going to do with that ultimate question is they're going to try to find ways to say, no, it wasn't caused by the accident. For example, they may try to use the issue of the accident happened on October 1st, but they didn't come see you until December 1st. Do you know what happened to the client in between there? Could something else have happened? They're going to try to throw out things. The property damage, did you see the damage to the vehicle? Could a slight impact cause an injury? Do you think that changes your opinion as to the cause? They were hurting beforehand. Did they tell you they were hurting beforehand? Does that change your opinion as to the cause? So those are going to be things that the defense counsel will try to do to change your opinion. Now, if you're told something that you didn't know about, be honest. But I think it's important that you try to get that up front. The meeting up front before the deposition can usually take care of a lot of those issues. But that's what defense counsel do.
Ron, what do you find the best way to address if they were a patient before the accident, maybe for wellness or for a different type of injury? What's the best way to address that?
Best way to address that is when the ultimate question is dealt with, state, oh, I was seeing this client for a wellness program. They were having issues with this part of their body. However, when they came in, they were complaining of a different part of the body. Make sure you make that distinction as to what areas you were dealing with, or if your wellness program, explain what the wellness program is. If there were no complaints, you're just trying to maintain them in a good condition, and there are no complaints. Explain there were no complaints. This is what we were doing, this is why we were doing it, to maintain their overall health. That is very important, as defense counsel will definitely try to address it, but it really falls on you to make that distinction as to what was going on.
What I found is that patient under wellness care has a minimal number of things to address, then they have this accident, and now they have all this stuff going on. So you can show them, I mean, would it be wise to show records of treatment before the injury?
Yes, I think it's very important to get those records out. One, it helps the attorney, the plaintiff's attorney, evaluate the case. And defense counsel is going to get those records. They're entitled to those records. They're going to find out about them one way or the other. So I think it's very important to go ahead and get it out. Absolutely. So that's the ultimate question, and that is the area where you're protecting your bill. So that's why that's so important. Kind of transition back to exhibits. If the deposition is not being videotaped, yes, there may be exhibits. You don't have to play the role so strongly, but if it's being videotaped, I think it's very important that you get your exhibit, and the plaintiff's counsel should make it, bring a light box, or if y'all have light boxes in your office, that you have the deposition where you can throw an x-ray up on the light box, so that you can actually get up there and point and show, hey, here's the problem. And the reason why is jurors love to see stuff. They don't like to hear people talk. They want to see something. And if you can point to a problem, you have just bolstered the case tremendously. So being able to point to actual exhibits during a video deposition is huge. If it's just a regular court reporting, it may be, okay, you need to circle the problem. Then plaintiff's counsel can go back during the trial and actually point it out during the trial. Okay, plaintiff's counsel's gone through their testimony with you. Now it's time for cross-examination. They're not trying to make you look to be a bad person. They're not trying to make you look like you're a liar. They're just trying to discredit the testimony, meaning weaken your opinion on why this injury was caused, weaken your opinion as to whether the treatment needed to go that long. However, anybody that's questioned on what they did or what their opinions are, you immediately take a defensive stance. I mean, that's just common nature. So, but try not to become too defensive about it, especially if it's being videoed, because the juror will appreciate it much more. If you show confidence in your position, no, this is why we did this plan. I think if you look at any article, you will see that 8 to 12 weeks is a reasonable amount of time to do the plan. Nope, I think this caused the accident because the client never had any problems with that area of their body beforehand. Yes, they may have had a problem 2 years ago, but they were working beforehand. They were doing their hobbies that they did beforehand. So show confidence in it, and that'll help the jury understand that you're not being defensive, you're just confident in your answer. But as I was stating earlier, the defense counsel is going to also try to point out, well, doctor, going through the records, the client missed 2 weeks of treatment here. Yes, they did. And this may be where reviewing the file beforehand, oh yeah, they did miss 2 weeks because they had to go to their aunt's funeral. You get a question about a gap in treatment, and you can give that response because you reviewed the file and remembered it. You just kind of punched them right in the face. So I think that's where it's important to review the file. But if you can kind of, oh yes, they were out, they missed 2 weeks, we tried to call them to get them back in here. We knew the importance of them maintaining their treatment. If you can have some type of response like that, I think it's very important on that.
Yeah, and a lot of times there is a good explanation for a gap in treatment, and it may be that, you were doing a great job and their pain had decreased a certain amount, and while you know that they need 4 more weeks of treatment so that they don't re-injure themselves, they don't think that, so they quit coming to see you, and they go back to work, and they're back in your office 2 weeks later and like, Doc, I really hurt again. My opinion is, if there's a good reason for it or they told you something like that, I would rather you say, yeah, when we discussed it with the patient, we recommended some further care. However, the patient thought they were well enough to go do this or reduce their number of treatments. As soon as they tried that, their pain went back up because their care wasn't completed. And just describe it right like that and talk about it if that's really what happened. The key here is always be honest, always tell the truth, always talk about what you know. But if there is something like that, or talk to the attorney about that ahead of time. What I will tell you is always just, don't do a very long answer, a very long-winded answer. If you're going on 3 or 4 or 5 sentences, it's probably too long. But don't be afraid to say more than yes or no either. Explain your answer. Just don't get drawn into an argument. And if he gives you a question, take a moment to think about the answer. The pause is never as long as it seems like it is to you. And it's okay to take an answer and think about it and then address it. Okay.
Yeah. Some other areas that defense counsel may use to try to discredit the testimony is, did you look at the vehicles? How could that collision cause the injury that you're claiming was the result of this accident? I don't think any juror or plaintiff's attorney expects you to be an accident reconstructionist. I think it's important for you to state that the person told me that this is the way they felt the impact. However, the car is designed to deal with that impact is not how the human body is designed to deal with that impact. I think it's important to state something of that nature because that question's coming every time. Did you go look at the car? No. Well, here's a picture of the car, and they'll flash you a picture of it. How could this have caused that accident? I'm not an accident reconstructionist. It's okay to state that. The next area I wanted to cover is, let's see. Oh, one other thing defense counsel may do is they may point out where you've set out a treatment plan, let's say 8 weeks, and you get down to the 7th week, and I know the question always is, how's the client doing? I'm doing good. Well, okay. Yes, my plan was to treat them in this time period. We're going to continue that to make sure they are absolutely okay. So if defense counsel says, well, doctor, didn't they say they were okay on this date, on this date? Yes, but I was continuing my plan. I think that's the appropriate way to deal with that. Yes?
Getting back to extended damage. I mean, there's volumes of research that show injury can occur at low impact. Mm-hmm. If you say that, had you better have the research available to back it up, or?
That's where I'm really concerned about a case where it's just chiropractic treatment, because you get into issues of, are we going to have to start bringing in an accident engineer? And then you get into issues, can the case afford that? I can't qualify you as an engineer. The cost of an engineer may run the cost outside the case, the value of the case, and now we've got a situation where my case is about to just collapse because I can't afford the debate.
So in other words, having documents is sufficient.
I don't think so, and I think you should just stick with treating the client. If defense counsel is wanting to bring that up, I have not been trained in accident reconstruction. I don't know if Shane shares a different opinion on it.
No, my opinion is pretty much with Ron's. The one thing I did want to say is sometimes there are factors, positional factors and stuff that exacerbate the injury and make it worse. And those are key areas for you to talk about because, one, you do know those areas vastly more than me as an attorney or from the defense attorney, and you can, talk about those very key. I mean, if the patient told you their head was turned, and you can say, well, I don't know about the property damage here, but what I do know is she told me this when she was in the car, and she told me she was looking at the radio, which would indicate her neck was turned this way, which, is going to make the force worse or something. You can talk about those specific issues that are wholly irrelevant to the amount of the property damage, and that bolsters your treatment pattern because you're talking about very specific things rather than getting into an argument with the other side about, all the research and stuff that shows damage is not related to the injury.
In dealing with the research also, if you open that up, it brings in the issues. Are we going to have hearsay issues where we can even continue that question? Or are those articles that the other side will stipulate to as evidence that we can actually present as evidence? So we'll get into those issues, and I think we'd prefer to try to stay away from it if we can, so we don't have to get into paying for an engineer, because that's the last thing you want is, okay, the defense addressed that with you, they go research those articles, they then hire a engineer. Well, we've got the appropriate thing for us would be to go depose that engineer before trial to find out what they're going to say. And again, the cost just kind of got out of control on us. So I think if you can just concentrate on the treatment, it would be better. But all right, medical bills. The question should always be asked: Are your medical bills reasonable and customary? Yes. I'm pretty sure y'all are probably out there testing the market just to see what people are charging for the treatment you're doing. But I mean, if you see that everybody's charging that rate, absolutely, yeah, that's reasonable and customary. That is, and be confident in that statement about your bills. Here's the issue: what if you're treating on a lien? How do you deal with that? I don't expect the plaintiff's attorney to ask if you're treating on a lien. I definitely expect defense counsel to ask you, how is this bill being paid? Well, we're on a lien, or we have deferred cost, or we deferred payment until the resolution of this case. Defense is definitely going to try to show bias in that you're trying to give your testimony so that you collect something here so that your bill gets paid. I think the way to deal with that is, whatever the outcome, Ms. Smith is still responsible for that bill, no matter what. All I've done is I've agreed to wait on my billing of the client until resolution of this case. That's all I've agreed to do, so that it really comes across that you want your money for the work that you've provided. You're just agreeing to delay it. I think that's how you discredit the defense trying to say that you're biased for your testimony there today. I would not try to avoid the question of a lien. Be completely upfront with it if it's asked. I don't mean go out and offer the opinion, but that, hey, we're on a lien. But if it's asked, yes, we are deferring our charges.
Until when?
Until the resolution of this case, then we will ask to be paid. The other issue on the bill is, what if you got med pay? What if you got health insurance? What if you got some other type of collateral source? I think if defense counsel asks you, has the bill been paid, they're entitled to know the bill's been paid. Try to keep it to a minimum talking about insurance, because the judge issues a ruling that you are not to talk about insurance. If you can answer the question, has the bill been paid? Yes, the bill's been paid. A good plaintiff's attorney would then say, off the record, or if it's being videotaped, let's go off record so we can talk about it off the videotape, that, okay, it was paid through medical payments coverage. It was paid through their health insurance. That way you can edit it for the jury not to hear it. If it's just a transcribed deposition, I wouldn't worry about it so much. You can just skip over it when that testimony is being read to the jury. But don't be afraid to answer that, but try to keep insurance comments to a minimum. Okay. The other big question is going to be, where did the client come from? Where did the patient come from? Did we refer them to y'all? Did y'all refer them to us? I would not shy from that question either. The way, let's say the client found you first and you suggested an attorney. I would use that word. I suggested so-and-so attorney. You may even want to say, I suggested multiple attorneys. You may even want to go say, even further and say, well, I suggested these attorneys because I've seen them in the past and I've seen that they will work hard for their client. That's a great word for the jury to hear. The jury will then have an understanding as to why you suggested that attorney. Let's flip it into the reverse. Let's say I suggested the client to you. The client came in. I'm not going to turn down any business. They called me. I said, I'd be glad to treat you. And I think it kind of shows that you're a very honest, open door, trying to run a business type person. Because, I mean, that's the truth. It's the truth, and the jury will see that it's the truth. But then the next question may be, well, have you had a lot of clients referred by that attorney to you? I've been practicing for so many years. I know that attorney's been practicing. That may be the hard question to answer. I'll admit it is kind of hard because it's going to show some type of relationship. I know that attorney practices in that area. I know that attorney works hard. I've been open for so many years. It's just kind of naturally evolved that way. However, then the other question may then be, well, how many clients have you treated from that attorney? I don't know. I don't keep up with that. I think that's the only way to answer that question.
One thing along those lines is, if you have a professional relationship with an attorney and you don't go out to dinner, y'all are not friends, don't say you're friends, okay? And the reason is because there's very particular case law out there that talks about this relationship, and I don't remember the name of the case, but what happened in that case was, I believe the chiropractor said, I'm great friends with this person, we have a very good relationship, and it was more of a social relationship. And as soon as that came in, that bias came in and opened the door to other issues. And my opinion would be is if you and I went to lunch on a professional lunch, you know, once every 6 months or even once every 3 months, but it's of a professional nature, it's okay to say, I have a professional relationship with him. Yes, we've done business together in the past. Or not even business, I wouldn't use that term. I would say I have treated patients of his in the past, yes, but it's because of this area, or I may have referred patients over to him, but once again, it's because he does a great job and fights for his clients. But emphasize the professional nature of that relationship versus the social nature of that relationship, okay? Now, obviously, never lie. If you did come to my kid's birthday party or you came to my birthday party, it's okay to say that. But make sure you characterize your relationship as it is in a proper format. Don't talk about it being social if it's not really that, okay?
Yeah. One other quick little area. What if you treated the patient before the actual injury? I think we kind of touched on that area. Definitely distinguish the difference. Plaintiff's counsel needs to know about it when they've requested the records. If the request comes in for the records, you've been treating this client beforehand, make a phone call. Hey, I've been treating this person beforehand. Do you want those records too? Yes, we do. We do want them. That way we can see, okay, this client had a pre-existing condition. We need to know about it. But if there's, okay, you were seeing them for a neck problem, we now have a back problem, we can go ahead and be prepared for that distinction, and y'all be prepared for that distinction during a deposition. That's really all I've got on a deposition. I just wanted to touch base on medical narratives real quick, and then I've got a couple other questions to answer, and then we'll pretty much be done here. Medical narratives, that may be where the business is evolving, is to obtain a medical narrative. You definitely are entitled to charge for your medical narrative. A lot of times if a medical narrative is requested, plaintiff's counsel is seeing a problem with the cost of the case. Maybe there needs to be a conversation, hey, don't charge me, I'm trying to get your bill taken care of. The last trial I did, I called the doctor. I said, I need a medical narrative, but please don't charge me. I am totally trying this case for your benefit of trying to get your bill taken care of. I think that communication needs to be had between you and the plaintiff's counsel. But you're definitely entitled to charge for it, charge whatever you feel is appropriate. But keep in mind what we're trying to do. A medical narrative needs to have your qualifications, needs to have the complaints of the client, your exam and findings, diagnosis, treatment. It needs to have the ultimate question answered. Did the accident cause the injury, or did it aggravate it? It doesn't need to be too long. It needs to be thorough, but not too long, because plaintiff's counsel is going to be taking that and actually reading it to the jury. So imagine if I'm sitting here reading a letter to you, how much you're going to enjoy that. So it needs not to be too long, but it needs to be thorough. And most important part is it's got to be signed and dated. If it's not either one of those, the actual code section says it has to be signed and dated. So make sure that that's always there. I don't think it matters when it was dated. If it was 6 months before the trial or 2 weeks before the trial, I don't think that's an issue. It just has to be signed and dated. That's pretty much on medical narratives. That's really all I've got to say on
all
that.
I want to say on that is if you use a medical term, you have to define it. And Ron may have said that. Also, a medical narrative is probably a different document than your final narrative report, okay? I know a lot of doctors' offices will do just a standard final narrative report whenever they release a client or a patient. The medical narrative, that's our terminology. It has a legal definition, so it's a legal document which may be different than what you normally do in your practice. And that's why as we're using the terminology here, it's that medical narrative report we're going to try to get introduced to trial. Okay, so if I call you and say, hey, I need a medical narrative, and you're like, well, Shane, did you read the notes? I provide one with every one of my cases. The reason is because it's a different document than just your final narrative report.
And one other thing, don't think that you've got to prepare it either. The plaintiff's counsel can prepare it. So that way we kind of get in what we want said, but the appropriate thing that should be done is we prepare it, get it over to you, you tell me, okay, no, we need to change this. I think that's the best way to do it, but y'all have hey, that's an okay. All right, get it over here to me, I'll sign off on it. Here's my bill, here's your narrative. I think that's the best way to do it. So, all right, a couple questions that were sent to us. Is there a difference between an evidentiary hearing and a deposition? Yes, there is. I hope y'all are never called into an evidentiary hearing. Because what's going to, I mean, you're actually going to have to go to the courthouse, and your testimony is really going to be scrutinized as to what you're testifying to. Either, I don't know, it may be an x-ray that you gave an opinion on. It may be, are you licensed and you're treating somebody and the case is in another state? I don't know what the evidentiary issue will be, but ultimately what's going to happen is you're going to be called into court. Defense counsel and plaintiff's counsel have already argued the issue, but then there's going to need additional testimony by you while you're up on the witness stand, and whatever the issue is, it's going to be hammered out, and you're going to have to leave your office, go down to court, wait your turn, and hammer it out. Can you charge for that time? I don't know. I mean, again, I think you're running into issues with the cost of the case. That may be something you want to address with the attorneys.
I'll tell you the details afterwards.
Okay. But the deposition hopefully is just at your office, and it's a lot.
An evidentiary hearing.
You got an evidentiary. I wish you luck. Then the other question was, when is a musculoskeletal condition considered pre-existing, and if a factor in a case, how is its presence minimized? To me, I think the best way I deal with it is try to find out from the doctor, and hopefully through your questionnaire of the patient beforehand, what were some of your hobbies? What was your work beforehand? What chores did you do at home? And that way, if they had a pre-existing condition but they're working, then they get in the accident, and now they're not working, well, then you've got something, okay, well, they had this problem, but they could work. Or they could go play golf. Now they can't. Or they can't, we had to get them back to that point to where they could go do whatever it was. And I think if you pick some activity, that can kind of help you distinguish a pre-existing condition. Yes?
Do you guys get to kind of like harp on the fact of like performing duties under duress in a situation like that?
We try to really use that. You mean, do they try to go to work when they're in pain?
Exactly. Or performing those hobbies or duties, you know, with what they did before, and now, like, since the accident took place, they can't really perform them anymore.
Yes, we really want that information from our clients to present it to the other side. And it's all to show that their life has been altered. And yes, we really, really like that. We even go so far as asking the clients to give us a narrative on their own, because you nor I will be at their home seeing what they do.
Yeah, and also it goes right with normally the presentation we want to make of the client, because if we have somebody who's a hard worker, who's working a job, and they may have been doing this job for years, then they get into an accident, especially with the economy the way it is now, they can't afford to lose that job. So even though you're saying, yeah, medically it would be great if you took 2 weeks off or 3 weeks off, and they can't, put in there. And I say put in the notes, hey, I recommended the patient, take work off. That would be best. However, due to the financial situations, they can't afford to take that time off. I think I like that story. I always like the story about somebody who has to work hard and who's doing the best they can and moving forward. And that bolsters right in there, especially if it's in your notes or if it's something they told you. Because it's just a better story. It's a better client. I mean, and jurors can identify with that, especially now with the economy the way it is. Also, when we're talking about pre-existing conditions, sometimes you may treat somebody and, before the accident on that pain scale, they're down to like a 4 or a 3. And they get into the accident, now their pain jumps right back up to an 8. See, that's an easy way to differentiate it and say, yeah, when they first came to see me 6 months ago, they had these issues, we worked on it, we got their pain down to this manageable level, and then the accident happened and it shot way back up and we started totally over it. If that's the case, just say that. Don't be afraid to. I tell people don't hide from pre-existing conditions, because usually they come out, and when they do, then they chop your legs out from underneath you and the case is trashed. But if you confront them head on and talk about it, normally my experience has been jurors understand that and it's okay.
Yeah, that's kind of our practice in trying a case is right there at the beginning of the case, even with the client, start questioning them, hey, did you have these problems beforehand? Or even when you're picking a jury, all right, would you have a problem saying that client had an injury even though they were already suffering from some other condition? Go ahead and get it out when you're doing voir dire with the jury. So yeah, we try to hit it head on. The jury understands it a lot easier. That's all I have. That's all I have. Any other questions or anything? Yes?
Do we have a right to see the, what's it called, disbursement statement or the check from the insurance company? If an attorney says, well, you know, doctor, we had to cut your bill 75%, I want to know if that's...
Not during the deposition, but we can talk.
Yeah.
We can talk about that afterwards.
Yeah, I'll be glad
to.
to answer that. I think if you ask 10 lawyers, you'll get 10 different answers.
Are there any questions shouldn't be answered during a deposition, or at that point would you guys step in?
And that's where that pause comes into play sometimes too. If they ask you a question and it seems weird to you, or you're like, yeah, I don't want to answer this, just pause for a moment, because I'm listening, or the attorney defending the deposition is going to be there, and that gives him a chance to object, put it on the record, and then he's going to tell you whether to go ahead and answer or not. Usually the answer is going to be, I object because of this, go ahead and answer the question.
Yeah.
But that objection pauses that testimony so we can go argue it before the judge. But if he asks you a question and you spout off real quick, it can be hard sometimes to go backwards and do that. Also, right along those lines, if you don't know something or you need to look at your notes, it's totally okay to say, can I check my notes? Can I look at this issue? I would much rather you do that, even on a videotape deposition, than be wrong and guess, and then the other side undercuts you. I think most jurors understand that you're doctors and you treat a lot of patients, and this is, far in time from when that treatment was actually there. So looking at your notes does not diminish your credibility at all, in my opinion.
I agree completely.
Well, if that's all the questions we have, that's it.
We're
I
good.
do want to ask you sort of a housekeeping matter. Is lunch the best time for you guys, or would like breakfast have been better, or another day of the week, or what, for something like this?
Lunch is.
Okay.
What about this location?
Isn't okay? Because we were going to ask, would it be better to be in a restaurant or something like that too, if we had a separate room, or is this good? Okay.
You like those chairs? I did too.
All right. Well, thanks, guys. We
Yeah.
appreciate you coming out.
Yeah.
We hope you learned something.
Yeah.
Thank
Thank
you.
y'all.